Placed the crook of his arm around her neck and squeezed. You know what you do when you squeeze somebody's neck? There's only one intent: to kill. Breathing comes in handy for humans. When you put somebody's hands around neck and squeeze, the only real reason you're doing that is to kill, that attempt to kill. Okay, we'll do him last, okay? Nicole Treadwell was dismissed?
Yes, I think that's for the
Okay. Then I've got Michael Horn. John? Michael Horn?
No, that one's going to be set on trial, adopted trial case. I'm not sure if they stay on.
Okay, I need Horn. Michael Horn, please.
just don't follow it. Forward.
It's another one of my favorite ones. Family violence. I just don't understand. It didn't grow up that way. Can't understand how it happens.
Yeah.
But it over and over again in this love. Well. '26 CR 387 is called. Michael Brandon Horn. Is that you?
Yes, sir.
You're here with Mr. West, your attorney, and the state's attorney. What are we doing today?
Your Honor, they has made an offer. My client is adamant to this and wants the trial, so set up some trial out.
Yeah. We get the objection, it's on the record. Objections, goes to the thing.
So the victim in this case is a sibling?
Sister, yes.
Sister? Her perception of the situation is completely different than his. Let's see.
Yes, Your Honor.
She tried to flee from him, catches up with her, strikes her in the neck with a closed fist,
He's like,
attempted to get away, slapped her in the face, grabbed her by her hair, pulling her hair, drug her on the ground, then stood up, grabbing her and placed his arm around her neck. Placed the crook of his arm around her neck and squeezed. You know what you do when you squeeze somebody's neck? There's only one intent: to kill. Breathing comes in handy for humans. When you put somebody's hands around neck and squeeze, the only real reason you're doing that is to kill, that attempt to kill. So you're charged with the third-degree felony of assault, family violence. But this isn't your first rodeo, is it, with the law? Let's see, you were convicted in 2019 in this court for illegal possession of controlled substance. After that became final, you committed the offense of evading arrest or detention, and were convicted of that in 23 in the court next door. You're looking at no less than 25 years to life imprisonment. This is a habitual felon. You understand?
This is where habitual offender laws really change the math. On its own, this charged third-degree family violence assault carries a much lower range. But because he's already got 2 prior felony convictions on the books, the minimum jumps to 25 years to life. That's not the judge being harsh. That's just how habitual sentencing enhancement statutes work once someone hits that third strike.
And it is illegal and a violation of the bond conditions, the orders of the court in all cases like this to have any.
Worth pointing out, this no contact condition isn't optional. and the judge makes that crystal clear before moving on. If he reaches out to her directly or through someone else, that's not just a bond violation, it's grounds for an entirely new charge. Courts take that condition seriously because it's specifically there to protect the victim while the case is pending.
To have any contact with a victim. Do you understand that? Nor anyone on your behalf. If I find out about it, I'm going to ask the state to indict for another charge and add that because you're not supposed to talk or have any contact with a victim. You haven't, have you?
No, sir.
Well, that lady wanted you prosecuted. And I can understand, especially if there's an attempt to kill. Never said for trial. I'm sorry, you interrupted, but the grand jury accuses you, and that lady states you squeezed her neck. Were y'all just playing? That's a rhetorical question. You squeeze somebody's neck, there's only one reason to do that, an intent to kill somebody. Everybody on the planet knows that, apparently, but you. Set it for trial. And let me find out from the state if he has any contact, because I'm going to ask that another charge be brought. Okay, that is all.
All right. Oh, let me get those back into patients. Our next file today is People of the State of Michigan versus Jamie Sheppers. File number is 26-366FH. Your appearance, I took them. I thought they were bringing him over. And who's right? Sense of the PSI.
The people do not.
Mr. Champion, the same.
Then, Your Honor, I was going to object to OV10, but in further research, it is scored appropriate.
All right. Thank you very much.
Could not have doubted the probation.
It's okay. All right. Thank you very much. Let's turn over to the people. Oh, wait, hold on. I will note that I went through the report and I did not have any notes for any potential corrections. Thank you. Now, Mr. Dunham, allocution, sir.
Thank you. Your Honor, the defendant, as the court is aware, pled guilty to 2 counts of aggravated CSAM and 1 count of using a computer to commit a crime. Recommendation is as indicated, credit for 132 days. Significant prior history involving minor victims. This incident involved late last year, the law enforcement receiving a tip that there were from a internet provider that there were CSAM downloads involving young children, bestiality, and infants. There was a search of the defendant's home. He was cooperative. His phone was seized and the CSAM was confirmed. The defendant himself was identified. The defendant did acknowledge he did enter the plea in this case. We believe that the recommendation is appropriate, and we would respectfully request that the court follow the recommendation.
Mr. Champion.
Your Honor, this is an unfortunate situation. Mr. Shepard, as the prosecution stated, has accepted responsibility. He understands this is an issue that he needs counseling with, and with that, we leave the rest of the discretion of the court.
Thank you very much. All right, Mr. Shepard, you have the right to make a statement. Is there anything you wish to say at all today, sir?
No, sir.
Great, thank you very much. All right, well, what the attorneys have said really covers it well. If you one might think and say, well, they didn't say a whole lot, but they hit the highlights. There are some convictions here that involve young people here and past. We also see a theft case involving a larceny in a building. And we see some prior criminal sexual conduct convictions back in 1998, 2001. Hold on. Okay. 2002, another criminal sexual conduct in the third degree. Sorry for my pause. I was just looking to make sure that there wasn't any status of events change that we need, but I can see why they're not listed. But anyways, now we had also a CSC third degree in 2000, or a couple in 2004. So quite clearly there is an issue as mentioned by the council involving the defendant's activities with young people. Here is basically just possession of child sexually abusive material, which we basically know as being child pornography here. And the court, while recognizing that the guideline is 87 to 145 as a minimum, the court is limited, as acknowledged inside the report, by the 2/3 rule, which is actually a statute handed down by the legislature. Therefore, the court, not needing to find any substantial compelling reasons to deviate from the guidelines, but actually to say, I'm not allowed to go any higher than the sentence the court will give. For counts 1 and 2, the court sentences the defendant to 80 to 120 months.
This part is a good example of how sentencing actually works in practice. The guideline range said one thing, but a separate statute, the 2/3 rule, legally capped how high the court could go. So when you hear the judge say the sentence looks below the guidelines, it's not leniency, it's the judge following the maximum the law actually allows in this situation.
Again, that is below the guidelines, but it's actually not when you consider the limitations placed on the court by law. As to count 3, which is the use of the computer, the court sentences the defendant to, and I'm just going to go 48 to 120 months. That is within the guidelines. It's right in the middle. And these convictions will run concurrent with one another. Have I missed anything? Oh, wait. $3 $68 state minimum fees, Tina. One $130 crime victim right fund fee. I'm not going to assess any other full costs, attorney fees, or fines, as collection would be most likely ineffective. Have I missed anything, Ms. Odell?
Your Honor, did you mention jail credit?
Oh, 132 days, right? Yeah, 132 days, Tina, for each one of those 3 offenses. I apologize. Thank you, Ms. Odell. Ms. Odell, anything further?
No, Your Honor, thank you.
Mr. Denham.
In the same count for both aggravated possession of police and Your Honor, just for clarification. The same sentence for both?
Yes, counts 1 and 2 have the same sentence of 80 to 120 with 132 days of credit. And count 3, using the computer, is 48 to 120 with 132 days of credit. Now, Mr. Shepard, what you are receiving from the defense counsel, Mr. Champion, is 2 copies of one document. You are to place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges your receipt of that copy. But the other copy, this document tells you that you have the right to appeal the conviction and sentence in your case. That's typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of that document and return to the court within 42 days. All right, Mr. Shepard, the way you've handled this case, pretty upfront, and I appreciate that. These are not victimless crimes because somewhere out there's a young person whose images were taken. But I think it's a fair and appropriate sentence, plus it's according to the law. Anything else, Mr. Champion?
No, Your Honor. Thank you.
All right. Thank you. We're adjourned.
That closing line from the judge is really the point of the whole hearing. Sentencing guidelines and statutes decide the number, but the judge makes sure the record reflects that there's a real person harmed behind every one of these cases, not just a case file.